Welcome back, LGL 130 students. It is Tuesday afternoon. Took yesterday off, but we're back now with another lecture. I think, and just so you know, there might be a stop and play because I have a kettle brewing for some tea. And I also have someone else listening to the lecture for free. Anyway, today we're going to talk about human rights law in both Canada and Ontario. And we'll probably do half of the slides that I posted. So we'll do part one, the overview to human rights law. We'll talk about Edwards and Canada and sort of the lasting ramifications that case at the Privy Council in London has had, and we'll talk about the Human Rights Code within the context of international and national human rights law. From there, we'll look a little bit in the next lecture, likely tomorrow, we will look at part 4 and 5, and I will get a separate lecture for the questions that were assigned last week up soon. So let's begin. Yeah, we're back. Okay, have a cup of tea, and it's a dreary Tuesday, and we are secluded here. So let's look at human rights in Ontario. And let's be as proactive about it as we can. So hopefully you have read the chapter. Sorry about that, chapter 13. And you have given yourself a little introduction. So really, this lecture discussion will just follow that, and I'll give you a little bit of the insights that I've gathered over the years about human rights law. Human rights law will show up again in many places for you during your studies here at Seneca, but in a major way it'll come at you in employment law. And so a lot of my slides have been sort of, because I lecture on employment law here and I practice it, a lot of what you'll see may have sort of applications for employment law. But let's just get back to it and start with the history. So let's move on to part 1. So I've included for you there two cases which make very clear points: Dolphin Delivery and Hill and Church of Scientology from 1995. And those cases, were amongst, in the early days of charter jurisprudence, they were looking to figure out how this thing, i.e. the charter, would work. And Dolphin Delivery was, as you can see, 1986, just said that the charter does not apply to private matters, so private law, Stewart suing Smith type of thing. There's no real application for the charter, but it did, say that the charter would need to. Sorry about that little break. But yeah. So Dolphin Delivery and Church of Scientology really, they were there to show that that the charter didn't apply to private law matters, but what it did do is that common law would need to be interpreted with charter values in mind. So so that was sort of, the charter is all about interaction with the state, a Canadian citizen or other individuals and the state. But we still, prior to the charter, had sort of, human rights codes and human rights ideas in Canadian law. So if you look at older cases, Christie and York Corporation, there were some, what we would see as obscene cases where discrimination on the basis of race was legal in the absence of a law specifically forbidding it. But then, various case laws, and especially after the Second World War, things would start to change, and we would take human rights, very seriously. So we can go back to Magna Carta in 1215. We can go back to the Bill of Rights in 1689, the U.S. Revolution, the French Revolution, these sort of episodic events in human history that, where people asserted their rights and what we would call human rights nowadays. Of course, the Second World War took human rights abuses to, a monstrous degree, let's say, with the Holocaust. And it was after that, in the formation of the United Nations in 1945 onward, that we saw sort of, the world come together and say, human rights has to be at the forefront of all law, not just, American law or Canadian law or British law or West German law, but everywhere. And of course, various states say they have human rights and they may not, and I don't really want to get into the weeds there. But, this is, the first Bill of Rights in the Canadian context actually happened in Saskatchewan. And if you'll recall Tommy Douglas, he was an NDP or CCF, as the party was back then, the Canadian Cooperative Commonwealth Federation. It was sort of a left-wing precursor to the current NDP, led by Tommy Douglas, who I think was born in Scotland, but was a minister, was a religious minister, and on the left wing of the spectrum, and seen in many respects as sort of one of the fathers of Canadian healthcare as we have it now, because he instituted those programs in Saskatchewan before they were instituted by Lester Pearson, the Prime Minister, in the 60s onwards. Or in the 1960s. So anyway, in 1947 we have a Bill of Rights in Saskatchewan. In 1948 we have the Resolution 217 of the United Nations, called the Universal Declaration of Human Rights. And that was a sweeping document. If you just go on the internet and read it, it is sweeping. It has rights, both positive and negative, meaning negative rights are sort of things that the state cannot do to you. Positive rights are things that you are entitled to. So, I think the Universal Declaration of Human Rights says that people have a positive right to housing. And, that, of course, comes into, can get a little controversial because it comes down to who pays for the housing. But again, the Universal Declaration of Human Rights, which the Canadian government signed on to, but, and I looked for it for this lecture, I don't know where we can find that, if it's been implemented in statute by the House of Commons and the Senate, the Canadian Parliament, but anyway, we are signatories to it nevertheless. In 1950, another Saskatchewan, born in southern Ontario, and a little hint, I visited his house in a place called Neustadt in just northwest of Orangeville, where I grew up. But John Diefenbaker moved to Saskatchewan when he was a young lad and became a lawyer in Moose Jaw, I believe, and eventually got elected to the House of Commons, became leader of the Progressive Conservative Party of Canada, and from there instituted a Bill of Rights for Canada, a Canadian Bill of Rights. Now, this was interesting because it was different, and we've talked about this in the context of the Charter. But the Bill of Rights was different because it was a federal statute. So it, in many ways, sort of was a precursor to the Ontario Human Rights Code, because that is also a statute, albeit a provincial one. But it says in the statute, the Human Rights Code of Ontario, that it has quasi-constitutional status. I don't think the Bill of Rights said that at the time. So the Canadian Bill of Rights was problematic in that it only applied to the federal parliament and the federal government, but also it was just, it could be changed willy-nilly. It was not an entrenched statute like the Constitution Act 1982 is now, which contains the Charter of Rights and Freedoms. So it was, we had a Bill of Rights, and then Ontario's first human rights statute passed in 1962. It prohibited prohibited discrimination on the basis of race, creed, color, nationality, ancestry, and place of origin. So it has grown. The rights have been, they've been expanded over time, but our first human rights statute occurred in the early 1960s. Okay, slide number 5. Let's move on. So after the war, we have this proliferation of human rights statutes and human rights codes, which is basically a statute in Ontario and elsewhere in Canada. But we've human rights and rights generally have been something that Canadians have been grappling with before that. So Edwards in Canada is a very important case in the history of Canada because it was it did a number of things. One which we'll talk a lot about, in this lecture, and the other less so, which is the other one, which is basically it implanted in this country the idea that the Constitution was a living tree, and so that the Constitution needed to be interpreted in a manner to sort of grow with the country itself. And the judgment given was a fellow named Lord Sankey, and he's a very interesting fellow. He was, I believe, appointed by the Conservatives, or elevated to the, he was a Conservative, but he did a lot of investigative work, like a commissioner work for the government into mining disasters and the condition of miners in Wales. And so he would, so he came back, and it really sort of spooked him. And after that point, he tacked more what we would call the left. And there's a great book written on the person's case, which talks a lot about Lord Sankey, by Justice Sharp, who I've mentioned in our lectures before, recently retired. But anyway, I digress. So I'll read straight from the slide itself. The British North America Act planted in Canada a living tree capable of growth and expansion within its natural limits. So not totally out, can't go too broad, but within the natural limits, the living tree of the Constitution was going to grow. The object of the Act was to grant a constitution to Canada. Like all written constitutions, it has been subject to development through usage and convention. Moving down to the next paragraph. Their lordships do not conceive that it to be the duty of this board. It is certainly not their desire to cut down the provisions of the Act by a narrow and technical construction, but rather to give it a large and liberal interpretation, so that the Dominion, to a great extent, but with certain fixed limits, may be mistress in its own house, as the provinces to a great extent, but within their fixed limits are mistresses to theirs. So a narrow, certainly not their desire to cut down the provisions of the Act by a narrow and technical construction, but rather to give it a large and liberal interpretation. So what does that mean? Well, let's talk about the context. The famous five women, the namesake being Edwards, wanted to be appointed to the Senate of Canada. So in the 1920s, it was the Senate was an abode for men only. Now, women had been granted the right to vote some 12 years earlier, but they were still not appointed to the Senate. And this got all the way to the Privy Council over in London, and basically it said, under the auspices of qualified persons, that women could be qualified persons to serve in the Senate of Canada. So it's called the person's case. It's not so much about whether, at least from what I understand it, and again, I'm not a scholar on these things, but from what I understand, it's not a, finally an assertion by the courts that women were actually human beings or persons in that sense, but they were actually qualified persons. And so the interpretation of the phrase qualified persons was to be given a liberal interpretation. And so that's sort of, in many respects started, and we would go down through history and see what we would call, a large, a liberal interpretation of rights, and how in our Canadian legal tradition, that is very much how it is. There's in law with any sort of rights, there's a purpose of. Sorry about that. In statutory interpretation, especially when dealing with constitutional statutes, we have sort of a purposive approach where we look at the purpose of the statute. What is the point? and from there interpreted sort of more broadly. So yeah, that's sort of where we are with Edwards. So let's look at part 3 now, and international, national, and provincial human rights. So um, looking at these various sort of instruments that represent that, the Charter, the Human Rights Code, the Universal Declaration of Human Rights, we look at the difference. So basically, we know the Charter. The Charter is there to protect your rights in many ways. Your right to vote, your right to be protected against unlawful search and seizure, your right to peaceful assembly, your right to vote, your right to cross, leave and enter Canada or to move Canada, your right, certain language rights if you are a French-speaking Canadian in Ontario, and so on and so forth. So there's many rights available to you with the Charter, but the Charter applies between governments. So we remember, the meetings that happened in the early 1980s that solidified the Charter, and we're coming up to the anniversary of the Charter signing. It was in early April. I can't remember the exact date, but that is sort of it. So all the Charter jurisprudence that is developed from that, from the Oakes test down to sort of Bedford and these sort of cases, they deal with you interacting with the state. The Human Rights Code has that element, but also is much more expansive in that it applies to you in, say, an employment situation. So if you are discriminated against on account of your religion, by your employer, then you can bring a claim against them under the Human Rights Code. So the code exists to protect people within a private law situation as well as a public law situation as well. And most likely, I think if someone had a public law issue, they would use the Charter. Let's say if they were discriminated against in a Service Ontario branch for some in some odd way, but the Human Rights Code is there to protect you as an Ontarian against other Ontarians if need be. The Universal Declaration of Human Rights is, again, sort of which Canada was a signatory, is a not so much, I would say, an instrument to be used in Canadian law now, except to say it might inform judicial decisions, but it's sort of, we are there as kind of to declare to the world that Canada is willing to abide by certain set of principles set out by the international community. So moving to slide 7, the Human Rights Code is considered remedial legislation. That means it exists there to right a wrong. So whenever you see remedial legislation, it's there to fix a problem. That's what it is. And it's there to fix something rather than punish an offender. It is quasi-constitutional in that it states that if it comes up against another Ontario statute, the code will prevail. It has quasi-constitutional status, and it prohibits discrimination on in employment and elsewhere on the basis of race, color, ancestry, place of origin, ethnic origin, citizenship, creed, sex, sexual orientation, gender identity, gender expression, age, record of offenses, criminal, marital status, family status, and disability. And of course, it's going to be rather expensive because, look at one like, say, gender expression. That wouldn't be as common, say, 30 years ago or 20 years ago as it is now. Key features of the Human Rights Code: it applies both in the public and private sector and to the conduct of individuals. So I can be held to account by the Human Rights Code. The 16 grounds which I talked about. It also prohibits sexual harassment as well as harassment based on other prohibited grounds. The intent is to discriminate is not necessary, and the effect of an employer or someone else's actions or rules will matter as much as intent. You can't contract out of it, so it's there. The code provides for civil remedies, so it's civil. So amongst the first cases I worked on when I was becoming a lawyer was at the Human Rights Tribunal of Ontario on Bay Street in Toronto, and you're very much it has the resemblance of a civil trial, and it doesn't have the bells and whistles so much in that everyone is dressed in suits and whatnot, and the vice chair was at the front taking notes on a laptop, but it's very much sort of similar to a trial, and basically it becomes a civil form. So damages are often, if not in all cases, what's sought, and yeah, quasi-constitutional status, and there you go. So it also says the code provides that everyone has a right to be free of discrimination in 5 areas: service, goods, and facilities, accommodations, contracts, employment, membership in vocational and trade unions. And just going down what we've already talked about, sort of the various descriptions on the prohibited grounds. Interestingly enough, discriminations that are not covered in the code, but that could be open to change soon. Language, although that can often find its way into other areas that are enumerated in the code itself. Physical appearance, political opinion, but that might change. What if you discriminate against someone who is a proud NDP voter or a proud Conservative voter or something? Who knows? So we'll stop it there. We're at 22 minutes, and I thank you for the little breaks. Again, we'll have more lectures later in the week, but I needed to take the day off yesterday. And I hope you're getting by. It's dreary, but we're all pulling with you, and just be safe. And I wish you all the best, and I will talk to you soon. Thank you.